Oh, and
It
Jack,
also violates something called the silver platter doctrine, which I don't think you've brought up in your case law, but that's something you should look into too.
oh, that's a new one. I'll have to look it up.
What
Anyway,
is the silver platter doctrine?
There is no way that a government, one government or another, be it the federal or any of the states, can, by a constitutional infirmity or a violation of law, hand another state evidence to be used on a silver platter. So it's an extension of the Fourth Amendment's prohibition against the illegal obtained evidence, or even ultra vires obtained evidence, or ultra vires processes, which is the core of Paul's case. I can't go to New York and say, look, I've got, as a Connecticut law enforcement person, say, hey, I've got all this illegally obtained stuff, but I want you to rebaptize it through the execution of this warrant. So if it's wrong from the beginning, you can't hand people stuff on a silver platter. It was handed to the Connecticut authorities on a silver platter by the Virginia authorities, but the Virginia authorities obtained this stuff because Connecticut prodded them and because it was done illegally. So it's a silver platter doctrine issue. It does not exist in the United States under domestic law. You still have silver platter doctrine under international law. So an international a sovereign could give stuff on a silver platter to somebody in the United States, but you can't do it between the states and the federal government.
yeah, and that's a new one. I'll have to use that. Thank you very much. Oh, and
it
Jack,
also violates something called the silver platter doctrine, which I don't think you've brought up in your case law, but that's something you should look into too.
oh, that's a new one. I'll have to look it up.
What
Anyway,
is the silver platter doctrine?
There is no way that a government, one government or another, be it the federal or any of the states, can, by a constitutional infirmity or a violation of law, hand another state evidence to be used on a silver platter. So it's an extension of the Fourth Amendment's prohibition against the illegal obtained evidence, or even ultra vires obtained evidence, or ultra vires processes, which is the core of Paul's case. I can't go to New York and say, look, I've got, as a Connecticut law enforcement person, say, hey, I've got all this illegally obtained stuff, but I want you to rebaptize it through the execution of this warrant. So if it's wrong from the beginning, you can't hand people stuff on a silver platter. It was handed to the Connecticut authorities on a silver platter by the Virginia authorities, but the Virginia authorities obtained this stuff because Connecticut prodded them and because it was done illegally. So it's a silver platter doctrine issue. It does not exist in the United States under domestic law. You still have silver platter doctrine under international law. So an international a sovereign could give stuff on a silver platter to somebody in the United States, but you can't do it between the states and the federal government.
yeah, and that's a new one. I'll have to use that. Thank you very much.
All right. Paul, can you hear me?
Yes.
All right. We're here today. We're going live, and we have a little bit of an exclusive interview with Mr. Paul Boyne, who is under prosecution by the Nutmeg State of Connecticut for free speech crimes. And so we're here today, and I think I have a little list that I could put together, or that I did put together. And let's see if we can put this here. Let's see. We have a list of all of the pending motions to dismiss in your case.
No. This is my list. If I was running this, these are all the.
That's what we're going to talk about. The public has a right to know how effective counsel would manage a case, or how a constitutionally, cognizant counsel, may want to attack this case. So we're going to talk about that today.
Well, counsel has one motion to dismiss based on overbreadth of the statute. And now, after 3 years from the door bash, we are actually trying to recognize Illinois and District of Columbia's decisions on the same law being facially unconstitutional.
Okay. And
now the list you have up here are the specifics, because the case is a mess. Every action that occurred in the case has a flaw in it. So I just went through
we're
and
going to get to that.
enumerated them. Yeah.
Yeah,
Okay.
we're going to get to that, but I want to do now, because we're just introducing this to everybody. Why don't you tell us from the beginning, okay, what this case is about for somebody. Let's pretend you're talking to a third grader who knows nothing about this. In the simplest terms, what is this case about? What are the facts? What's going on?
Dear little fifth grader, don't criticize your masters.
Oh, man.
This goes all the way back to probably around 2014, when there was Twitter accounts making memes mocking these family court judges in Connecticut. I mean, those were even written about in the CT Law Tribune by Norm Pattis, and I think he used the word screed, and everybody loved them. And people wrote them up. They got posted on these Twitter accounts, and they were primarily targeted at one point on one judge. And I guess then she got upset, went to the FBI and said, people are making memes from pictures that I have on my Facebook account. And of course, the FBI, there was some backroom arrangements there. So next thing you know, the FBI shows up down here in Virginia in 2017 because the First Amendment exists. And of course, they went away. Nothing happened. I mean, the underlying probable cause was some federal interstate stalking threat statute, which never survived a grand jury anyway. And then everything went away until what was it, early morning, June 30th, 22, when Virginia State Police SWAT team bashed down my front door to seize the fruits of free speech. And then nothing happened for a year, and then an arrest warrant showed up, and what was the charges? Oh, stalking. Yes, 18 felony counts of stalking by political speech, which, for your audience, Illinois dealt with that back in 2017 at the High Court and said, yeah, that statute is facially unconstitutional. And then the High Court of District of Columbia had to deal with it. I guess it was in June of 23, came out and said the same thing. The DC Council actually struck down the law while that case was going on because they realized it was all screwed up. But for some reason in 2021, Connecticut enacted the exact same law that Illinois had found unconstitutional 4 years before.
That's the case of Relaford v. Illinois, correct? And the other one
yes,
is
and then
Mashad Biboon
yes.
in D.C. Okay.
Yeah, and then of course the bill that introduced the exact same flawed language was, according to Steve Ginsburg of the Connecticut chapter of the ADL, was written by him, but he just copied the Illinois law. And that was passed unanimously. Nobody voted against it. Nobody did any research to figure out it violated the First Amendment. And in fact, there was even public statements by Blumenthal's little kid, Matthew, I guess, who said, no, it doesn't affect free speech at all. And obviously, he never read the Illinois case law either. So now there was testimony when that law was passed by the ACLU saying this law has big problems when it comes to speech. And I think, that law probably does have purpose. If somebody's, some crazy woman is obsessed with Mr. Luthmann and following him around everywhere and photographing him and collecting his hair samples and going through his garbage. Yeah, you could probably get a stalking law out of that. I mean, that's physical conduct. But boy, the minute you touch political speech, matters on public concern,
a case?
You're done.
We'll back up real quick after this about the blog and about the speech. Wasn't there a case about Obama and threats? You know, the famous case goes back to Watts versus United States with LBJ, where the guy said, if I get drafted, the first thing I'll do when they give me a gun is I'll shoot LBJ. And the Supreme Court said that is a constitutional speech, it's protected speech, it cannot be criminalized. Wasn't there a recent case about Obama and gun threats that you had cited, or that the blog had cited?
I try and jump from a lily pad to lily pad. Watts, since you do mention it, that was such a simple case for the Supreme Court. There were no oral arguments. It was a per curiam, whatever you call it, decision. And the thing people don't realize about Watts was a black man on the mall near the Washington Monument being surveilled by basically Army military police. And, you know, it was Big Brother hunting for dissenters against the war, which really goes all the way back to Schenck in 1919, you know. But anyway, yeah, you're right. You got Watts, you got Brandenburg v. Ohio, you got Claiborne Hardware. And then what happened in 2011 in the Ninth Circuit, it was called Bagdasarian, where this guy named Bagdasarian had posted things about, I think the specific item was, he asked on some message board or online chat room, when does Obama get a 50 cal to the head? All right, you know, and there was political discussion. Obviously, people weren't happy with what they perceived Obama was. And there you go. So when does this guy get a 50 cal to the head? I mean, you can go back to Shakespeare and, you know, you could say, when does this guy get the et tu brute, you know? And so anyway, the Secret Service found out who he was, went to his house. Yes, he had guns. Yes, he had a 50 caliber gun. Yes, he had 50 caliber ammunition. He was very honest. He showed everybody everything. And then they came back with an arrest warrant and they arrested him. Goes all the way up to the Ninth Circuit, and Ninth Circuit says, no, give me a break. And that was on, you know, threatening the president statute, which is a little narrower.
He talked about 50 cal to the head. And so let's fast forward to the blog. There's a blog, which I have behind me, the familycourtcircus.com blog, and I'm managing it now. And prior to my management, it did a lot of the same things that we still do now, in that we exposed corruption in the family courts and in CPS and in those areas in a very, very provocative way. You know, through straight reporting, investigative reporting, but also satire and over-the-top commentary to make our point. And so prior to my administration, so to say, at the blog, there were some articles put out that I think have been termed the Hateful Eight. There are 8 articles, and those articles talked about some of that language that you just discussed, 50 cal to the head, and you talked about the Shakespeare, where the first thing you have to do is kill all the lawyers and things like that. And so, what happened with all of those Hateful Eight articles? Talk to me about those Hateful Eight articles.
Well, the only reason we mention the 8 is because we have been asking the court in Connecticut for the particulars of the crime, and the court has refused to order a bill of particulars where the state would actually have to write down on paper exactly what was said or whatever the criminal words are that they're basing their prosecution on. And we pushed that issue a number of times, and we finally, Judge Brown ruled that these 8 articles form the basis of the prosecution, the 8 essays. He didn't say what in each of the essays. He just said these 8 essays. And so whatever is in those. Back
up. There are 8 blog posts, and these 8 blog posts form the substance of criminal activity for the state of Connecticut. Okay, in the state of Connecticut. So That's the core of this case. There are 8 posts on a blog, the Family Court Circus blog. Those blog posts are still up and available for the public to consume and protected under the First Amendment, and they've been basically kept for spoliation purposes because evidently the Family Court Circus.com site is a digital crime scene. So, you know, who am I or anybody else to interfere with a digital crime scene? But let's go back now to what happened. There was a crime. I'm going to put up the graphic again with your motions because we'll start from the beginning, and with that in mind, we'll get into what happened and why these motions you believe are the important motions to be filed with the court. So let's talk about these motions. Start with number 1, MTD 1, the violation of shield laws 54, 30, 33 I and J, subpoena not search warrant. That's Judge Gold in January 22. What's that all about?
All right. In 1978, there was a Supreme Court case involved the Stanford Daily News. I think it was that called Zurcher v. Stanford Daily News. And anyway, the police raided a newspaper with a search warrant looking for a picture that they thought was criminal or something. And there was a big uproar, said, no, you can't invade the press with a search warrant. And it made it to the Supreme Court, and the Supreme Court said, oh, yes, you could. All right. So the next year, a bunch of states passed what were called shield laws. So if there was anything involving the press, our free press, remember, this was 79, okay? They said, no, you have to issue a subpoena. Okay, and then of course the subpoena has due process. You know, the media outlets can go to court and move to quash it. They just don't break down the door to the newsroom and start going through all the journalists' files. Well, Connecticut has those shield laws. So technically, once they figured out that my credit card was on the subscriber list, which again, that was a violation of Fourth Amendment too. But anyway, they should have issued a subpoena, and the subpoena would have come to folks handling the blog. We would have challenged it in court, and there would have never been any of this, because they would have to have proven to the court at that time in the subpoena challenge that there was criminal speech. And quite honestly, since it would have gone across state lines from Connecticut to Virginia or other places, you know, we probably would have taken it to federal court. And Jack Doyle and Judge Brown wouldn't get away with this stuff saying, oh yeah, there's 8 bad essays that we think are criminal. That wouldn't have flown in federal court.
Who's Jack Doyle?
Oh, Jack Doyle's a prosecutor. He was handed this, you know, it's like his personal baby. He was like an executive state's attorney. He wasn't assigned to a particular judicial district. And when Patrick Carroll made the complaint to...
That's Jack Doyle right there.
Yeah, and Patrick Carroll, who was the chief court administrator in June of 20, made the complaint to the chief state's attorney. You know, it went to the state police, and Jack was the state's attorney working with the people in the state police who were hunting free speech. So he's been on this thing for, you know, 5.5 years.
And so who's the other woman in the middle?
Oh, that's Joette Katz. Joette Katz is a retired Supreme Court justice. She's a partner at Shipman and Goodwin now. And she wrote a op-ed in the Connecticut Law Tribune in January of 22, claiming the blog was not free speech, it had crossed the line, and it was clear and present danger. Now, you'll remember Clear and Present Danger went out in 1969 with Brandenburg. I don't think she got the memo. So anyway, that was kind of like the shot across the bow, telling the world the blog isn't free speech. Well, the same time she was publishing that, in January 22, Judge Gold, who, well, whatever, Judge Gold signed a search warrant applied for by Jack and Sammy McCord, which they took to the federal court to get the subscriber information for the blog's hosting company. Which again, you know, as I say, every
I think we have a picture of Judge Gold right there. Is that Judge Gold?
Yeah, well, you know, you're never going to see him pictured with Easter baskets or, you know, a Christmas tree. But yeah, no, I mean, Gold has actually been the villain here because Jack takes everything to Gold, Gold signs it. So he signed that initial search warrant, and then he signed the search warrants to invade the computers that were stolen from Virginia, and then he's signed the arrest warrant. So Gold is like, I think he's
that's the real David Gold, not the subscriber.
yeah, that's the real Judge Gold. He's Joette's right hand man, and it's pretty sad, you know, when you read what they put in front of him, and you know, obviously he's not very. Oh, let's just say he probably does what he's told. I don't believe for a minute that a man who's been around for that long and has practiced in law would sign what was put underneath them. And then, of course, you know, when he signed that search warrant in January, so he obviously didn't realize Connecticut had shield laws. So he blew it right out of the gate. You know, they brought him the search warrant, and he didn't know anything about the shield laws, and they could have issued a subpoena. Okay, they could have sent a subpoena down to the internet hosting company. They would have forwarded on, and we would have dealt with it. That would have been what is called a due process under the 14th Amendment, which Judge Gold has no idea of.
All right. So, and I'm going to put up a picture of our friend. Here she is. All right. And this is our buddy, Justice Katz. And yeah, I'll get it up in a second. Tell us about what you found in your discovery related to Justice Katz and the significance. Okay.
You know, one thing that we being a rather extended network of people that kind of care about each other, one of the things that we do is we help people, especially mothers, that the Connecticut court separates from their children. And these mothers don't have money for lawyers. And there's a number of people who've been through this divorce game in Connecticut. And they have files and files of pre-written motions for everything. And a lot of women have some problems. Well, not problems. I mean, there's big anxiety issues in dealing with the courts as just a regular person. And of course, they're trying to get their kids back. They can't hug their kids because of some discretionary order of these family court judges. So anyway, long story short, they have electronic filing in Connecticut. So a lot of these motions these women file, you know, get uploaded onto that system. Well, this guy named Carl Cicchetti, I guess they realized there was a particular IP address that was uploading a number of motions onto this system. And so Carl Cicchetti, who's an absolute idiot, he decided somebody, namely me, was practicing law without a license. I wrote a memo to the Chief Justice Robinson, claiming because this IP address was being used to upload stuff on different cases. Therefore, it was a violation of law. So it went to the Chief Disciplinary Council. They had an investigation, and for some reason, Samantha McCord was involved.
Who is
And
Samantha? Who is Samantha McCord?
Samantha McCord is a Connecticut state trooper. She's now retired after 25 years of service, and she was the first openly lesbian trooper to graduate from the Connecticut Police Academy. And we're all supposed to celebrate that for some reason. Anyway, so she's been running this thing since June of 20 when it got assigned. And she's been the principal instigator and
I think you got a
violation
picture of her
of
right here. Is that her?
yeah, something that looks like her. And she's not a nice person. Let's just say that. And but I mean, this lady actually wrote up a petition to the U.S. Department of Justice headquarters in Washington, claiming she was hunting anti-family court vigilantes. That was her actual words in the petition. And she had been hunting the blog. The blog had lived overseas on, when it got set up or something. And she was actually harassing a company in the Netherlands as a state trooper of Connecticut, demanding, information on the blog. And of course, they couldn't respond to her. So she actually applies to the State Department through the U.S. Department of Justice for mutual legal assistance treaty, and asking the State Department to go figure out who's behind the blog. And the word she used was anti-family court vigilantes. And actually, I think, that's where Volpe had got named in that too, by that FBI agent, Lisa Tutty. He was a anti-family court vigilante, and he was harassing people, and, all this free speech, all this public scrutiny of matters in a public forum. The law enforcement people turn it into, vigilantes. So anyway,
Mike Volpe is an excellent journalist out of Chicago, investigative reporter, covers family court stuff with me on a podcast, and he does a lot of great other stuff. michaelvolpe.substack.com if you want to read his stuff. And he just did a recent interview with Paul as well, which is pretty good. So go ahead, Paul.
But anyway, Katz's name came up. There was this email you got up on the screen, I guess. Samantha was having a discussion with Brian Staines, who's the chief disciplinary counsel, on the telephone, and these were her notes. And she wrote this note down. Obviously Staines told her to talk to Katz. And
now at this point, what's the date on that? What's the date on that email? It was like Tuesday, April 18th, 2022. Right? Does that sound about right?
Yeah, whatever's on there, I can't see it.
Was Katz in government service at that point in any way?
No. At that point, she was a partner at Shipman and Goodwin, and somebody tried to say, well, maybe Katz was on the, some committee of the Bar Association that determines whether or not people are engaged in the illegal practice of law. And and I said, well, that's kind of stupid, because if you read the statute, if you're going to go after somebody for illegal practice of law, that means like walking into a courtroom and pretending you're a lawyer, or charging somebody.
The unauthorized practice of law is related to the physical practice of law. So that's the
right. But I mean,
representing people, holding yourself out as an attorney at law. You're fully protected under the First Amendment, under your free speech rights or associational rights, to discuss freely
issues of concern, even issues of legal concern, as they.
Oh, wait, let me back you up. You don't need to go to the First Amendment on that one. The practice of law is a common law right of everybody. We all have the right to, quote, practice law. The part about being regulated to represent other people and represent people to the court, that's the Bar Association. But as
Yeah.
far as practicing law, discussing law, writing motions, providing opinions, legal research, that is a common law right of every citizen in the country. But the Bar Association doesn't want you to know that. Yeah. and needless to say, uploading documents to a computer system is hardly a practice of law, but that was the probable cause that generated that investigation.
Let's move along here, because that we talk about here. We talk a little bit about motion to dismiss 1. Motion to dismiss 2 is related to a glow host, which is the server that you would have went to federal court and would have went against any type of warrant that was ever issued, and that never happened. And we talked about Sammy McCord. Now, who's this Sponheimer fellow? Why don't you tell us a little bit about motion to dismiss 3?
Well, real quick, number 2, the magistrate Judge Spector issued this order in the District of Connecticut, which they gave to McCord, and the McCord sent it down to Florida. I don't know how that works. I don't understand how Connecticut can issue an order upon somebody in Florida. But anyway, we'll move on.
So you think that's a jurisdictional issue because it would have.
Oh, I think that's total flaw, right?
A local, not a local, but either a federal or a state court that had jurisdiction over a glow host, and they didn't do that.
Like I said, they're in Florida, not in Connecticut. I do not see any reason why. Okay. Yeah, but anyway, okay. So the communications of McCord to Doyle and Sponheimer, whatever. There was a memo. It's rather lengthy, dated the 18th of June 22, that went to Sponheimer, which Sponheimer basically cut and pasted into the search warrant for Virginia. And then he cut and pasted it, and he prepared his Virginia search warrant, and then he took the direct. Yeah.
Back up. You are a resident of the Commonwealth of Virginia.
Yes, I am.
And Connecticut was investigating you.
Obviously.
And before this even happened, they had some type of Connecticut Gestapo court security unit that had a big report about you. Is that correct?
Yes, the 94-page comprehensive report on Paul Boyne. I think that dates from 2022. They're having a tough time finding the 94 pages. They have 13 pages, but who knows?
There's 94 pages that were referenced by people. Do you have a copy of that, or do your lawyers have a copy of that in discovery?
No, they have the 13 pages. They're still looking for the rest of it.
They gave you a sanitized version of the full report.
Actually, I'm sorry. Judge Brown has prevented me from having any possession of any of this discovery.
Oh, really?
I had all the. Judge Harmon, said I could have copies of the first dump that we had, which was probably 2,400 pages. And, I got that when I was in prison. And then, for some reason, Brown decided that I can't have this stuff. I mean, which again is a flaw in going to a jury trial, because if I don't have it and I can't study it, I can't be an informed defendant. But, Brown plays some really silly games. It's pretty scary. So, so all I know is I know what's discussed in court. And
so you're in the Commonwealth of Virginia. That's where you're physically present. They're in Connecticut, and so they're trying to obtain evidence to prosecute you in Connecticut. So talk to me about how they went about it.
Well, from what we can piece together, the earliest contact between McCord and Sponheimer, and we had no idea how they found each other, was January of 21. And that's all we know. And then there was, I think, discussions in April of 22, because that's the month we figure the feds dropped it. Because remember, in January 22, there was a federal case that they adopted Gold's search warrant, and they had the FBI involved, a agent from Connecticut called Ron Offit. They had a couple of assistant U.S. attorneys working on it. You know, it went to Magistrate Spector. And then it looks like in April or May, they dropped it. They walked away. They must have told Connecticut at that point, sorry, there's no crime here. This is political speech. Now, I did talk to Ron Offit, the FBI guy, and he told me he never swore out a search warrant, never swore out a complaint, never said there was probable cause of criminal activity in the blog. Okay, so we kind of figured out what was going on there. You know, the feds walked away from this in 2017, and the feds walked away from it in April of 2022. Okay, so what was left to do? Well, we can't get them with the feds because the feds say it's not a crime. So how are we going to get them? So what do? They go to Virginia. You know, and they basically everything. It looks like Sponheimer basically thought he was working for Connecticut. He did whatever they said. They gave him information. He pasted it into the search warrant, and then after he drafted his search warrant, which was nothing more than pasted information that he obtained from McCord and Doyle, he sent the draft back to Doyle and said, or back to McCord, and said, here's my draft. Is this what you want? And then after McCord said, oh yeah, that looks good, then he took it to the judge, you know, saying, oh yeah, I swear to this. But he didn't tell him, he didn't tell the judge anything. Like, oh yeah, the feds, you know, walked away from this twice, but we're going to go after them. Didn't even tell the judge that there was 2 old folks who lived there. Got permission to do an early morning raid, because normally search warrants are supposed to be served when the sun is up. And and I mean, just the pieces that we're getting and we're seeing is Sponheimer was not being a sworn law enforcement officer. He seemed to just be a puppet of Connecticut. And then even in this memo of 18 June, which is signed by Doyle, it says the Virginia State Police will seize the property and hold it temporarily and then give it to Connecticut. Well, the raid was over like at 7:15 in the morning, and they gave the property to McCord at 7:30, and it was out of Virginia by lunchtime.
Let me talk about that. Let me talk about that. Let's break it down real quick. On the screen now, I put up something you alluded to earlier, Jack Doyle's motion. He said on or about May 14th, 2025, criminal discovery that was not authorized by the state, or importantly by a court, to leave the custody of prior defense counsel or the defendant made its way onto the internet, specifically onto the familycourtcircus.com. See, Boyne strikes back. Is Jack on crack or just plain whack?
Jack is whacked.
Here's the point now. Was that material part of the court file that he was talking about?
Yes. See,
talk to me about that.
What tripped them all up, and this goes back to, well, for you legal beagles, it goes all the way back to Map v. Ohio, and there's statutes which are exactly the same in Connecticut and Virginia that says if I'm an aggrieved person by, you know, an unreasonable search, I can petition the court, you know, for a hearing and to get my stuff back. Well, I filed that in Connecticut because Connecticut had the property. And I filed the motion. It's called a 54-33F in Connecticut. And it went to Judge Calistro. And it basically got in February of 23. And in March of 23, March 20th, Calistro marks it off. They trash it. They denied me access to the court. But what nobody knew was somebody left it in the file with a yellow sticky on it, which said marked off per Calistro after discussion with Jack. And we found
that was published on the familycourtcircus.com blog. That paperwork, which was available in the court file, correct?
Well, see, Jack is so stupid, and his sidekick Borelli are very ignorant people. They never gave us that. We found it in the GA23 files. Okay, they actually had a special file, and it was called either Jack's file or Boyne's file, where they threw all this stuff that they didn't process. They had like 4 of these motions that I filed. There was even one in the file from the 1st of June, because after I figured out they must have trashed the one from February, I filed another one, and they just took that and threw it in the file. They didn't even try and docket it. So we took it.
Wait, hold on.
What?
Slow down. Jack Doyle went to the court and represented that this was a piece of discovery, when in fact it was not even a piece of discovery. It was not part of discovery that he transmitted to you or to your counsel. And he can't prove that he transmitted it to you or your counsel. Yet he went to the tribunal and he represented in the tribunal that it was discovery. Is that what you're saying here?
Oh yeah, no, he had no clue what he was talking about. And then
now, don't you get in a lot of trouble if you're a lawyer and you don't have candor towards the tribunal and you make misrepresentations?
Well, maybe in a real court of law, but we're talking Connecticut here. I mean,
Doyle has ethical problems. You think he should be disbarred?
Oh, I think that memo of June 18th, 22, I think that's going to disbar him, because the memo he sent down, because this memo he sent down to Virginia was basically his opinion of probable cause of a crime. Well, he doesn't get to determine that. That's a judicial determination. So if he was trying to transmit probable cause to Virginia, he needed a judge's signature. He didn't do that.
So here's my question. Here's my question for you. You talked about MAP v. Ohio. MAP cites a case called Elkins versus United States, and it establishes something called the silver platter doctrine. When we came on today, we talked about that back, I think, in June or July, when you and Volpe had a conversation, and we talked about the silver platter doctrine. You had never heard of it at that point, and then you started research. Talk to me about some of these motions: Motion 4, Motion 5, Motion 6, and the silver platter doctrine. What's going on here?
To sum it up, at 5:15 in the morning, they broke down the front door. I mean, they hit it with a battle axe. They had a gun pointed at my head with through the window with the rifle sight light on. I mean, right there, that was a violation of Fourth Amendment, unreasonable execution of the warrant. So that should have stopped everything. I went to court a week after the raid, and that's when the court was informed that the property was gone and given to Connecticut. Now, right then and there, the court should have realized, but quite honestly, in criminal court, the judges and the lawyers don't really know the law, and they're always focused on the elements of the crime. But anyway, in Virginia, when a court issues a search warrant and property is seized, that property is inventoried with the court saying we have this property. And by law, 19.2-58, it's to be held securely until further order of the court. But it was gone by 7:30 in the morning, and the court didn't open till 9. So obviously there was no court order. So that was a violation of Virginia law. So they should have recognized right then and there was a problem, ordered Virginia State Police to get the property back as a violation of law. But sometimes things just don't go the way the law is written. And so anyway, right then and there, the property could not be searched, because in Virginia, they did something very interesting. They added a statute that says you can't search anything without a search warrant. So they made it a statutory bar to unreasonable searches, which is a lot easier than going the constitutional route. So basically, when the property went to Connecticut and then Judge Gold issued search warrants to invade the property under the Virginia court jurisdiction, again, he violated the Virginia law, because there was no Virginia search warrant to invade that property, which was under the jurisdiction. And by the way, it is still under the jurisdiction of the Virginia court. And that's a point that I've made recently to these people, telling them that, look, you might think you have this property, but you don't realize you broke the law in Virginia. Connecticut broke the law in Virginia. We got it. Okay, now give the property back to Virginia, and we'll clean this mess up down here in Virginia. But you go back to 1928, and Brandeis said, the government cannot break the law to obtain a conviction. Well, you broke the law, so I guess this case is over.
And so we have a situation where Jack Doyle and Sam McCord and others in Connecticut are acting in concert with the Virginia authorities on a Virginia search based on a Virginia warrant. When they're acting, are they private individuals or are they state actors, Paul?
Well, they're acting in their official capacity. I mean,
as actors of the state of Connecticut, correct?
Well, yeah, no, I mean, Connecticut acts through its courts, its legislature, its executive branch, and McCord's in the executive branch. And you got to be careful when you say Virginia authorities. It's only Sponheimer.
But Sponheimer is a member of law enforcement.
Yes, he's a member of law enforcement, but the problem becomes Jack uses that term all the time, Virginia authorities. He was not talking to authorities, plural. He was talking to Sponheimer, singular.
Gotcha.
And when
he's like a rogue, he's a rogue agent, you think?
He was not working for Virginia. He was working for Connecticut.
Okay.
I mean,
I got a question for you. Jack has been going to Judge Brown saying that he's requesting the materials from Virginia. Is there some type of defect in how he's requesting materials? He doesn't have it yet, and they haven't handed it over. What's the problem from your perspective?
Well, Jack uses this investigator, and I don't think this investigator understands how the union is formed and what a state is. So he's talking to Virginia State Police, demanding all this, demanding everything. And the guy on the other end says, oh, well, you'll need a court order for that, which that's the law in Virginia. Well, Jack didn't like that answer, so he escalated it. So I don't know what that means. He got on the phone and yelled at somebody. And then he was told, well, you can make the request through the portal, P-O-R-T-A-L. Well, when the Virginia State Police refer to the portal, that's the Freedom of Information Act portal, which is an online computer system, which you basically put in your request for a FOIA, and they give it to you based under the FOIA laws. Well, it sounds like he did that, because the only term he uses in court is request. I've requested that from the Virginia State Police, but he doesn't say how. I mean, whether it's a subpoena or a court order or a FOIA request, he is very short on specifics. when he runs his mouth. So what we figured is he got the first dump on FOIA because they wouldn't give him the internal affairs reports. Now, we do know that the head lawyer within the Virginia State Police, a guy named Tom Lambert, when he heard about the raid back in 22, he actually directed internal affairs to open an investigation because, in his words, he said, "I fear there will be litigation on this." So he knew within, a few days of the raid that this was a problem, directed internal affairs to do an investigation. And I think there was something I came across. I think Sponheimer refused to be interviewed by the internal affairs people, because Sponheimer knew he screwed up. And then, but as far as the internal investigation reports and everything, we haven't been able to get those because I don't think Virginia State Police is allowed to release those without a court order. And I have not seen any effort on the part of Jack to ask Brown to issue an order that they could take to Virginia court and get it domesticated. Because I think if he does that, he knows the case is blown. Because can you imagine a hearing in the Virginia court with a representative from Connecticut's AG's office demanding internal affairs reports from Virginia State Police for having violated the Fourth Amendment on a raid that Connecticut asked him to do? I mean, I don't know if there'd be enough room for all the TV cameras in the courtroom for that one. So my guess is Jack is never going to ask for that order, and this will just continue to drag on. Because if you get everything on the table that happened down here in Virginia back in June of 22, the case goes out. You're done.
Yeah,
And I mean, all you got to do is put up a picture of the the smashed front door, and under Virginia law, the police have a burden to prove that the search was executed reasonably.
So I want to, we'll talk about on our list here. We talked about 7, and then we have 8, 9, then 10. Our stuff about material facts being concealed, and that and there were the things that were not stated. I'm going to have you talk about that a little bit. I'm going to ask you though, who's this guy? I'm going to ask you to talk about this guy real quick. Who's this guy?
That's Todd Bussert, director
he's
of
a pretty good
complex.
lawyer, right? Wait a second. He's a pretty. I did research on this guy. I spoke to some people about him. He's admitted in the United States Supreme Court. He's a good lawyer. How's he been performing for you?
In my opinion, this case should have been over 5 minutes after the arrest warrant was issued. I mean, and here we are 3.5 years after the door bash party, and I'm still awaiting the trial. I mean, proof is in the pudding. He came on like in, I don't know, March, April, somewhere in there this year. Okay. The number one issue of this case is the Relaford decision in Illinois and the Mashad decision in District of Columbia. Now you put those two decisions on the bench and say, would you please dismiss this? Okay. Nobody's done that. And quite honestly, Jack Doyle has never even, I mean, that's exculpatory evidence, quite honestly. If you have 2 other jurisdictions in the country saying this violates the Supremacy Clause, this violates the First Amendment, why did you hold Mr. Boyne in jail for 18 months? So how is this case going?
Hold on a second. So I'll put this list back up, okay? this is the motions that you believe should be filed, and you say that this guy that Todd Bousert, this guy has only filed one motion to dismiss based on overbreadth of the statute. Where's the disconnect there? Is there a strategy, a legal strategy that he has? Is there legal judgment that he believes that those motions are merit?
Well, what I was told by all these lawyers, I think we went through, Todd's the fifth one in Connecticut, right? Maybe the sixth, depending how you want to count it. You know, when I always bring up this thing that the charging statute is facially unconstitutional, I'd be told, oh, no, not in Connecticut, it's not. Or I'd be told, well, that'd be a motion to suppress, and that would come after the jury's selected. And I was given all these excuses, okay? And it wasn't until, I don't know, more recently, maybe within a month of when Todd just recently filed this motion to dismiss on overbreadth, where, you know, this idea of a plea, in order to plead out with the right to appeal, there has to have been a proper motion to dismiss that was denied. And I brought this up saying, look, you know, I can't even plead out at this point because the previous motions to dismiss were written by idiots and they're not proper. And if you tried to go to the appellate court after pleading out and saying, oh, well, you know, we had this motion to dismiss and it should have been granted and it was denied, the appellate court would look at it and say, no, that was a stupid motion to dismiss and it was properly denied. And now you have no right to appeal your plea. So I said, look, I can't plead. I can't plead out, you know. So unless somebody files a real motion to dismiss that gets denied, okay,
motion to dismiss
plead.
that you would want would have all of these 12 components in it and put it before the court properly. And then at that point, you would feel that you would have the opportunity to even consider taking a plea at that point. Is that what you're saying?
Right, because I need a proper motion to dismiss to be denied in order to
so you
plead.
Preserve your appellate right.
Yes, exactly.
Okay, now my other question for you is, would you take a plea at this point? If, let's say you come in and I'm Jack Doyle and I say to Todd, this is enough. This case is a pain in my ass. It's a pain in your ass. Paul's a pain in the ass. Let's give him, he already spent a year and a half in jail. Let's give him time served and we'll give him a stay away order. Just stay the fuck out of Connecticut and everything is fine. And that's that. You know, and we'll talk about your ankle bracelet in a second. He gets his ankle bracelet off. He gets to, you know, do what he needs to do. Let's say they did even something like that, because I don't think like Jack is capable of doing that. I think he's going to try to do some type of a First Amendment infringing type agreement where you can't post anything, you can't do anything, you can't speak, which would be crazy. But let's say he gave you a bare bones, just stay the hell out of Connecticut and go away, time served. Would you take that deal?
Does it come with dancing girls?
I don't know, but is there a deal that you would take right now just to end this thing? Is there a deal? They put a deal on the table that was like, all right, fuck it. I get this ankle bracelet off. I don't have to deal with these people ever again. I don't have to take the train from Virginia to Connecticut anymore. I'm not going to deal with Brown and his carnival. I'm not going to deal with anybody. I'm going to deal with Jack. I move on in my life. Connecticut moves on in their life, and that's that. Would you take that deal?
There's a problem there.
Okay.
There's not a deal.
Okay.
I went down that road, okay, you know, this summer or whatever. And I think the communications from Jack was that there is not a plea offer right now.
So he hasn't made a plea offer. How much money is he spending over internet posts? You know, you got people dying of fentanyl. You got people in New Haven getting shot up left and right. You got all sorts of real crime in Connecticut, and yet they're spending millions of dollars at this point to prosecute you, and there's not even a deal on the table to cut costs.
Well,
seems a
that's
little
what,
crazy to me. Is that what you're
Yeah.
saying? There's not even a deal on the table by this guy over here, Jack Doyle. There's not even a deal on the table that he's going to put to cut the cost of the Connecticut taxpayers. You've been a year and a half in jail already for internet posts, and hasn't a deal on the table just to end this case.
I don't think he's allowed to.
Why do you say that? Who do you think's controlling Jack Doyle?
Joette.
You believe Joette Katz, who's a private citizen, is controlling Jack Doyle and the prosecution of you?
You know, if you look at, let's just name names here. You got Joette Katz. You got Damon Kirschbaum. You've got Judge Gold. You've got Judge Levine. Judge Levine is the head, or Levine, I believe it's pronounced. Judge Levine is the head of the Governor's Hate Crimes Council. Jack sits on the council. Okay? You look at who's on that council. All those people are involved in this. Okay? You think they're going to roll over and give up their premier hate crime stalking law? You think for all the effort they went through to get that law passed and signed into law by Lamont in 21, they're going to stand up and go, oh my God, it's facially unconstitutional. Oh, sorry, Ned, we got you to sign the wrong law. They're not going to do that. No,
So
they're not going to admit defeat. They're riding the tiger. They can't get off.
all right, so I'm gonna play something then right now. And you tell me how far in we need to go on this, but I think this video is one that you've seen before. Let's see if we got it going. Who's in this video? Tell me.
Oh, that's Joette Katz goes to the Never Is Now November 22 ADL hate something convention in the Javits Center in New York City.
All right.
And, you know, it's where they all come together and say anybody that says bad things about Jews is a bad person.
You know, we were
Well, do you
listening
think
this morning about, obviously, all the atrocities and horrific things going
But
on
listen,
in
do
this
you say
country.
bad things about Jews? But is it your constitutional right to do so? I don't say bad things about Jews, but, you know, some people have a right to do it, don't they?
Also commented on is
Go-
what I wanna comment on,
Go
and
talk
that
to
is,
Judge
let's
Easterbrook.
not
He was
forget
the head of the
First
Seventh
Amendment,
Circuit.
and in fact,
Hud
that's
Well,
nut.
no, wait. We go down here. See, motion to dismiss 12. We'll get to it in a second. Religious bias, probable cause, stalking. And so, you know, part of what they did was they made your
I'll leave that to our academics.
one of the bases for probable cause the fact that you've made anti-Semitic remarks or allegedly made anti-Semitic or hateful remarks. Is that true?
Thank you so much.
According to Judge
But
Keegan
let's remember
and Samantha
the other
McCord,
side of
those
these
who
conversations really is
exhibit
about.
bias
We were
against
committed
those
to
of the
First
Jewish
Amendment
faith
protections, and they extend
is
to
probable
ideas that are
cause of
intellectually
stalking.
indefensible and to speech that is
So-
morally obnoxious. Okay, so that's a given.
All right. So I'm going to go forward. I think there's a portion in here where she talks actually about you. See if we
No,
can
she
find.
talks about the blog.
Words exception. And
She-
now, having said
I
that,
mean-
the court continues to breathe life into the fighting.
She
words.
says that she's
And
been
more than
threatened for
75
40
since
years and,
Shapinsky was
you
decided,
know,
the
threat.
United States Supreme Court, and certainly the dictates of social norms will diminish the scope of its applicability. And I would
Let's see if I can find. I think it's.
to Erwin
Not so-
It really doesn't matter. I mean, the point is, you know, she talks about the blog there. She writes about it in the CT Law Tribune. Obviously, the blog is under her skin. She does not like what the First Amendment protects. And then her opinion is it crossed the line.
Here we go. I think
Well-
this is the part about Chaplinsky where she talks about.
as recently as 2011, the court, you know, obviously things have changed. Absolutely. I do think they would still uphold it. I don't
She says they would uphold Chaplinsky versus New Hampshire. Do you believe that's true?
the court cares
Oh
about.
no, the Connecticut
So I
did that
think
in
no reason,
in
frankly,
State v.
to agree or disagree. I don't see them overruling the concept of second-class things.
Liebenguth.
They may tweak it a
which
little bit,
was a
depending upon the
decision written by Palmer based on Chaplinsky, which says if you call a black man the N-word, he will explode into violence. So therefore, the N-word is a fighting word, and it is punishable.
This is beyond First Amendment protection. So I think it would still be good law.
So
a follow-up question is, would the words Jews will not replace us in the context of Charlottesville be considered fighting words? I mean, I think start with it depends. If there's a crowd located outside a synagogue and they're in porches, and someone says that.
Is that what you were doing, Paul? Did you have torches and pitchforks ready to go outside a synagogue?
That's going to be problematic.
Oh God, who told you?
If you're a Jew in Charlottesville,
No, come on.
we're marching down.
Right. So putting aside whether it's going to provoke.
I know who this guy is. He's some type of professor or something. Who knows?
Yeah, they get all sorts of peoples with labels, and you're supposed to think that they know what they're talking about.
I think I think that's the part coming up where she talks about you. But they're talking about Chaplinsky. So, and Katz thinks Chaplinsky is good law still. I don't. Here she is.
Again, going back to facts and circumstances, there was a case from 2015. The 10th Circuit reversed a district court because it said the district court incorrectly concluded that defendant's statement in the letter to an abortion clinic physician that an unidentified someone might place explosives under the car, and the district court said that was not a true threat. And the circuit court said, guess again, it is. Because although it might have been an ambiguous statement, there was enough in terms of the direct statement of personal intent. So that's one example. Another one is with regard to a formal, different set of circumstances, obviously, but involving university. Letter sent to by a former doctoral student to the university board that said bullets are far cheaper and much more decisive than legal action. And a person with my meager means and abilities can stand at a distance of 2 football fields and end elements of long-standing dispute with the switch.
That sounds like familiar, Paul, huh?
So,
they're talking. You can turn that off. They're talking about examples where something was communicated directly to somebody. Okay.
That's very true. That's very true.
It wasn't an essay. It wasn't, a essay on matters of political concern. I mean, it's one thing to say, I'm gonna shoot you if you don't give me your horse. Okay, yeah, that's probably a true threat. Okay, but if you're writing about a family court where we say, back in the old days, we hung people for stealing horses, and what should we do today about people who steal children? Okay, somebody can look at that and go, oh well, you were implying that we should hang these people, and well, no, it's a political essay.
Paul, who's this guy? You mentioned Relaford, you mentioned Boone.
This is Eugene Volk and Volk, and Eugene clerked for Kolinsky in the 9th Circuit. He clerked for O'Connor at SCOTUS. He was a professor at UCLA Law for many years. He is now in the was it the Stanford Institution or something?
Stanford. He does Reason. He does the Volok.
Yeah, but he's a fellow there, man.
I read it every day. He sends out a daily newsletter. I read it. It's very
and he wrote amicus. First time I came across his name, I think, was it's U.S. v. Cassidy out of the District of Maryland, which is really a federal case that's exactly on point to what Connecticut's doing. And he wrote the amicus in there, and Judge Titus, shot down the federal charges, and Mr. Cassidy went home after 6 months of being in federal prison. And the federal court did not even appeal Judge Cassidy's decision, which was in line with what Eugene said. And the Electronic Frontier Foundation was involved in that case. And in fact, that case we found after the FBI showed up here in 2017. And, we went back to court and said, knock this shit off, go read US v. Cassidy. And of course, guess what? That was the end of it. They gave me my stuff back.
They knocked that shit off.
They knocked that shit off. And
how come have you Professor Hollick, the essence to help?
Well, wait a minute. This guy's even more complicated than that. When the same exact stalking law came up in Illinois to the Supreme Court, he wrote an amicus. And quite honestly, I gave that amicus to Todd, and I said, look, I'm sure if you call Eugene, he'll let you copy it. That's a motion to dismiss. And then in DC, in the Mashad v. Boone case, Eugene wrote the amicus there. In fact, Eugene went to orals at both of those. Okay. And you listen to Eugene and you listen to how he describes the First Amendment, and, and you look at Connecticut and you're going, obviously Connecticut doesn't listen to Eugene. They whatever's going on in Connecticut, the principles of the First Amendment that he has studied and been learned on, and other courts have upheld, just don't apply in Connecticut.
You think he doesn't want to go to Connecticut because he's afraid of losing?
Well,
he's got a really good record with amicus. He's a very respected person about in First Amendment and Second Amendment issues and civil rights issues. If he goes to Connecticut and the fix is already in and he loses, doesn't that hurt him? Is that maybe why he's not getting involved?
Well, let's just say that Eugene doesn't do Easter baskets either, okay? And you got to understand that there's a reason the ADL pushed this law and resurrected it in Connecticut. Okay, you can't tell me that all the people in the legislature didn't know that this law had been torpedoed by Illinois when they passed it. All right, they were trying to bring it back to life, because you can do a lot of damage to your political adversaries or minority opinions or even majority opinions with this law.
Yeah.
I mean, it's so vague and so overbroad that if somebody gets scared because you said something, well, all they need is somebody to sign an arrest warrant and you go to jail. And that's coming from forces beyond the people of Connecticut, because the sovereign people of Connecticut don't go for this stuff. All right. And I think Eugene realizes what's going on. I mean, there's been a real effort during the Biden administration to undermine the protections of the First Amendment. And, so we'll just leave it at that. I know where Eugene is, okay, as far as, the powers that be in the world. He's not going to go running to Connecticut and say, you people screwed up. You should have never passed this law. Didn't you see what Judge Freeman wrote in Illinois back in 2017? You think Judge Freeman is an idiot? You think all the people in Illinois are idiots? You think all the people in DC are idiots? I mean, if you had the 7 high justices of Illinois and the 8 justices of DC, because they did it en banc, that was 15 high court justices saying the law is facially unconstitutional. So what's Connecticut's problem? There's a big problem. And I don't think Eugene wants to get involved.
And what's your charge? You're charged of stalking in the second?
No, stalking in the first, or
Oh, it's
18
50
counts, 18 counts of something or other, you know.
It's first degree stalking. Okay, let's get that. I'm gonna get that up. Let's get that up. That's 181, 53A-181C.
C and F. I get the electronic version as well.
Really? Well, let's F, electronic stalking. Here we go. That's a nice one. Let's put this up. Okay, electronic stalking. Let's how do I put this now? To the screen for everybody to see. Present a share screen. I'll do a screen share, and then there we go. Share. Okay, are we looking at that now? Okay, we have that here. Stalking. Okay, excellent. And that is a, let's see. A person is guilty of electronic stalking when such person with the intent to kill, injure, harass, or intimidate uses any interactive computer service or electronic computer service, electronic communication system, or electronic monitoring system to place another person under surveillance or otherwise engage in a coercive conduct that, one, places such other person in reasonable fear of death or serious bodily injury, aid to such person or immediate family member of such person, an intimate partner, or two, causes, attempts to cause, or would reasonably expect to cause substantial emotional distress to a person described in A, B, or C. For the purpose of the section, immediate family member, spouse, parent, brother, sister, blah, 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 anybody in the household, blah, 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 blah. Okay, so it seems to me this is the same argument you had before, that it was A to B. This statute looks like it's intended for an A to B communication. And the communications that the hateful eight they said that you did was A to the world, Paul Boyne to the world. Paul Boyne published an opinion, wrote an essay, and so it doesn't even look like it's the A to B type scenario. Is that the argument that that Todd is making in his overbreadth of the statute?
Well, no, the overbreadth comes from First Amendment jurisprudence. You know, you got the vagueness, overbreadth, chilling, viewpoint discrimination.
No. I get that. But when you say overbreadth, you're saying that the government is applying a law in a way that it was never intended to be applied. So that there's a
No, overbreadth means you're sweeping protected speech.
That's what I'm trying to say.
Yeah,
We're saying the same thing.
Yeah,
We're saying
but
it was to put in published publications of ideas and opinions. It was meant to do A to B conversations and threats and everything else.
well, I mean, when you're dealing with the First Amendment on matters of public concern, then what this law is saying is that essays on matters of public concern, if they offend somebody, they become criminal.
Yeah.
I mean, under this law, Comey could claim what people are saying about him is criminal, or Latita James, or
Everything is criminal at that point.
as long as I'm scared of something, then whoever made me scared is now a criminal. And it's just gets to be ridiculous when you apply it. But
so I want to ask you. We touched on the religious bias and probable cause of stalking. We can talk about that again. But I wanted, what were the material facts? This is like we're gonna sum up and after this. But you tell me what is not before the court right now? What material facts have been concealed in those 9, 10, and 11, or 9 and 10? And you can talk about the arraignment if you want. And then how are you going to get these motions to dismiss properly in front of the court to make a determination? Do you have a strategy? Is it something you intend to do? What's going on with that? And then we'll close up and let you sum everything up. So.
Well, real quick, as far as the strategy goes, I mean, I'm not in a court of law. All right, we're riding the tiger, so I guess the strategy is wait till the tiger dies, and then it's safe to get off. You can't have a strategy in a field of constraints that are unknown. And Judge Brown's court is the unknown. So back to the concealment, I think it picks up with the search warrant that went to Judge Gold to invade the computers that were in Connecticut. In that search warrant application, they did not tell Judge Gold they were obtained illegally from Virginia. They did not tell Judge Gold that the law of Virginia had been violated in order to obtain those computers. So Judge Gold issued a search warrant, which under the Fourth Amendment is void. Then when they went to get the arrest warrant from Judge Gold, again, they didn't tell him this is based on a search of the computers, which we stole from Virginia illegally. We did it by breaking down a door, improper execution of a warrant, yada, yada, yada. That wasn't declared in the application. So Gold signed the arrest warrant. So it goes to Virginia. They arrest me. I refuse extradition. So they had to go to the governor to get a demand warrant. They did not tell Natalie Braswell, who's the governor's counsel, of the errors that were committed by executive agents, Sammy McCord, in Virginia. And so Braswell advised the governor to issue the demand warrant. Nor did they even advise Braswell, or could Braswell figure it out, that the charging statute, the stalking, was found facially unconstitutional in DC and Illinois. So Natalie Braswell just, told Ned, sign it. So Ned signed.
They didn't present the governor of the statute under which this was being done.
Say what?
You need a probable cause determination by a judge. You need probable cause that the criminal activity is afoot. And so they would have to apply to a specific law that was broken.
Yeah, but hang on. Well, the finding of a probable cause by a judge translates to, did the judge sign it? Yes. Then there was probable cause. Did the judge write down what the probable cause was? No, they never do. But as long as he signs it, therefore.
Wait a second. Before they sign it, in order for them to be able to have the capacity to sign it and make a probable cause determination, you have to have a law or a statute or something that was violated or was what may have been violated.
Oh, right? Yeah, but no, I got that. But all they did in the application was write down all this terrible stuff about these 8 essays, and then in the concluding paragraph saying, therefore, I think these stalking violations occurred. That's all it says. There's nothing that says this is the probable cause of stalking.
No, but do they have the specific statutes enumerated so that the
oh yeah, no, they on the arrest warrant they have 181 C and F, yes. But
okay,
the problem
but the Virginia authorities, when they reviewed it, did not catch that it had been.
Time out. When Gold issued that warrant and they put it in NCIC or whatever, and they called the Virginia State Police and said, okay, we're going to get him. And Virginia State Police says, well, sorry, we can't go to his house and arrest him. He has to be in a public place. So the next thing you know, I get a summons from the clerk to come to court, in front of Judge Smith. And that was just a setup, because Smith wasn't even listening to anything I said, about getting my property back. And when I walked out of the courtroom, there was 9 deputies and a state trooper there and to arrest me. So, but what I'm saying is, in all those applications to Gold and to the governor and whatever, they never disclosed that they had violated Virginia law. And then Lamont sends the demand warrant down to Youngkin. Now, Lamont didn't tell Youngkin, oh, by the way, my agents were on your territory last year and we took the shit, and we didn't get a court order, and we broke your law, but I want you to render Mr. Boyne anyway, okay? Yeah, we violated due process. We violated the sovereignty of Virginia. We don't care. We want you to render Boyne. Well, then that goes to a guy named Richard Cullen, who's actually was a big dog at McGuire Woods, who's counsel to the governor. And he writes a one-page legal sufficiency opinion saying that the demand warrant is legally sufficient and Youngkin should issue the rendition warrant. And, you know, I reached out to Cullen and I said, you had no idea what was being withheld from Governor Youngkin. He could not have made that informed. It was a discretionary decision to render me, and he was not properly informed. So quite honestly, you can't exercise discretion if they hide all the details from you.
Gotcha.
So, you know, I went to Cullen and I said, you know, go call Glenn and tell him you screwed up. You had no idea what the, you know, the misrepresentation was from Connecticut, and that you shouldn't have rendered Boyne. And the other thing I told Cullen was, why don't you go read Relaford and Boone? And if you had known that at the time, would you have told Youngkin to render me? No. Any lawyer would have said, oh shit, sorry, Glenn, you can't render this guy, you know, and not under this law. And so anyway, so he renders me, and, you know, and besides that, there's a whole nother story coming out. You know, I never got a habeas hearing here in Virginia, so we knew that the judge in Virginia was in on it. They were just like, you know.
I heard that you're filing something in Virginia. Is that happening?
Yeah, well, it's very interesting. You know, we took the return of property motion back to the court and said, yeah, this stuff is in Connecticut, but it's still under the jurisdiction of this court because this court issued the warrant. And it was just amazing. These little clerks that are paid to push paper adjudicated that the Virginia court doesn't have jurisdiction because the property is with the court in New Haven.
Wait. A clerk made this determination, not a judge?
Oh, yeah, I should send you that email. The clerks are adjudicating the jurisdiction of the circuit court, which, quite honestly, is well above these little clerks' abilities to comprehend.
That's a violation. That's not, you can't.
Well, it's
so
they
beyond... refused to take your motion because they said they didn't have jurisdiction. The clerk's office did that? Yes,
and then it got all the way up to the chief clerk, who repeated that. And I asked him, the guy's name is Chris Falcone, and he's a lawyer. And I said, look, it really doesn't matter what a clerk's opinion is because it's not a final decision of the court. So I can't appeal a clerk's ruling on adjudication of court jurisdiction.
True.
And so it became very clear that this little clerk was told what to tell me. And we have it in writing, by the way. I'll send it to you. Even down to the detail that, you know, I have to go to the Superior Court in New Haven, Connecticut. And I'm like, how did this little clerk know that the property was in New Haven, Connecticut? But anyway, so we see the fingerprints of the powers that be. And because if that motion goes into the court and they recognize what we all know now, the case in Connecticut is dead. And they are fighting that tooth and nail. There's actually a Virginia.
You get a Virginia order that destroys the Connecticut case.
It's known to everybody right now. I mean, the Virginia State Police know that the raid, the search, everything was wrong. The judges down here know it. They don't want to have to deal with it. I mean, Brown, he's got to know it. Jack knows it. I mean, everybody knows it. As Brown once said, it's the elephant in the room, okay? And so what we're doing now is what was I going to say? The Supreme Court of Virginia issues the rules for the clerks. And it says in 1.16 parentheses little b, a clerk cannot refuse a tendered pleading. Okay.
Yeah.
But they are. And
That's a
and
violation.
well, it's a violation, but what it's telling you is the entire circuit court is working tirelessly to ensure that motion does not come before it, because they already know the answer. And then once they rule on it, Connecticut's case is done. And everybody knows it.
All right.
I mean, it's simple.
Paul, so we've gone about an hour and a half already. So let's sum up. I'll give you the last word on your case and what everybody should take away from this.
Big Brother is alive and well. Your Constitution is meaningless. The people in Connecticut who we see are not the people driving this. There's a dark hand that's controlling what happened in Virginia and what happened in Connecticut, and don't kid yourself. Okay. And, and right now, Judge Brown, he's not following the law. I mean, Jack, he's done probably 4 or 5 things that will get him disbarred if he was even in a real court system. And, it's a dangerous world we live in right now. And these are the people that are doing it. So be careful.
All right. Those are the words. Be careful. So, Paul, thank you very much for coming on today. We're gonna get this out there, let the people see it. What's the next steps for your case? Are you supposed to be going to trial anytime soon?
Yeah, they follow the bouncing trial schedule date. Trial right now is end of February. There's a status conference tomorrow on the lack of discovery. And I'm sure they'll probably reset some dates because everything we've asked for has not been produced. And, the one thing that Virginia State Police are sitting on is the internal affairs reports documenting the botched raid. So we don't have those. So that's going to come up again tomorrow. And
is your lawyer gonna raise the issue that that Jack hasn't made a formal request to Virginia? He's going through a FOIA portal, and that seems pretty significant to me.
They both talk around the issue. I mean, Jack started that wording, I've requested, and nobody's paying attention. But in the peanut gallery, they're saying, well, how do you request something across state lines?
Yeah, that's a big issue.
Well, guess what? And nobody's talking about it. So does that tell you what's going on?
Do you raise your hand, and say, Judge, I need to make the court aware of something? How do you get it in front of Judge Brown?
It wouldn't matter. Right? Let me tell you what happened. When it came out, I think it must have been February or March of this year. In court, I was handed a document that came from Jack's office. Nobody had read it. I sat down and read it, and it stated the property was seized without a warrant. I handed it back to Todd, and I said, hey, I think you got a problem here. And they had a discussion with the judge that the property was seized without a warrant. And Jack said, oh, no, there was a warrant. But again, he didn't say it was a Virginia warrant, and it didn't matter in Connecticut. And then, they have this uncanny way of avoiding the substantive issue.
So you're saying Jack has a lack of candor to the tribunal, a pattern of
he's concealing. I mean, McCord and there was wait a minute. There's two. Hang on. hang on.
Misrepresenting. Is that what you're saying?
I didn't hear you. Let me just give you an example. All right, deal in facts. There were 2 Connecticut state troopers the morning of the raid. They witnessed the door getting bashed down. Okay?
Okay.
Did Jack disclose that to the court? No.
Yeah.
Okay.
But it's not Jack's job to point out Jack's bullshit. It's your lawyer's job. What's Todd going to do tomorrow?
Well, I'm sure Todd would be happy to come on for an interview.
Yeah. I've been trying for months to get him, and he won't say a word.
No, he won't. He won't. And because he doesn't want to answer that question. Hey, Jack, why didn't you put it right on the bench in front of Brown about the botched raid that Jack knows all about? Why didn't you subpoena McCord to come on the witness stand and tell the court what she was doing in Virginia? Okay, and there seems to be this big pregnant pause. Oh, well, until we have all the discovery, we can't do anything. Or, maybe we have to wait till after jury selection to file a motion to suppress. I mean, excuse after excuse after excuse. And, you're just sitting there after a while and you go, it's pretty obvious what all these 3 guys are doing. I mean, it's obvious. I mean, you pull the transcripts, you read them. I mean, it's just, it's clear as day what's going on.
All right,
I mean,
Paul, we've been
anyway.
going for a while.
Yeah.
I'd like to thank you for coming on today. We'll probably do another bit with you in a little bit, probably after the holidays. So I'm going to wish you a happy or a Merry Christmas. I know you celebrate.
Merry Christmas,
And-
a holy
and then-
season. Enjoy
right.
that.
Yes, and then for your other friends, happy Kwanzaa and all the other Festivus and of course there's Hanukkah. I know you don't celebrate Hanukkah, but some people celebrate Hanukkah. So happy Hanukkah to those people who will definitely be watching this stream. And so thank you very much for coming on today, and we'll see you soon. Thank you for everybody out there for watching.
All right, take care. And
it
Jack?
also violates something called the silver platter doctrine, which I don't think you've brought up in your case law, but that's something you should look into too.
Oh, that's a new one. I'll have to look it up.
What
Anyway,
is the silver platter doctrine?
There is no way that a government, one government or another, be it the federal or any of the states, can, by a constitutional infirmity or a violation of law, hand another state evidence to be used on a silver platter. So it's an extension of the Fourth Amendment's prohibition against the illegal obtained evidence, or even ultra vires obtained evidence or ultra vires processes, which is the core of Paul's case. I can't go to New York and say, look, I've got, as a Connecticut law enforcement person, say, hey, I've got all this illegally obtained stuff, but I want you to rebaptize it through the execution of this warrant. So if it's wrong from the beginning, you can't hand people stuff on a silver platter. It was handed to the Connecticut authorities on a silver platter by the Virginia authorities, but the Virginia authorities obtained this stuff because Connecticut prodded them and because it was done illegally. So it's a silver platter doctrine issue. It does not exist in the United States under domestic law. You still have silver platter doctrine under international law. So an international a sovereign could give stuff on a silver platter to somebody in the United States, but you can't do it between the states and the federal government.
Yeah, and that's a new one. I'll have to use that. Thank you very much.